James, it's intro time. Do you want to tell us a little bit how you met Darren?
So Darren and I first met on a matter for a client where they were in some hot water, as we so often do. That's when clients tend to get lawyers and consultants involved to help them solve a problem they've got. Sometimes you meet people who you just work really well with and you just click with. He was one of those people for us, and basically ever since, he's been our go-to for any planning and environment law related questions. We always go straight to him first. And I should say, so a bit of a bio for Darren and Daniel is that they are both directors and principal solicitors at a firm called Bick and Steele, which is an environment and planning law firm. And they've helped us out with many, many things over the years. I've lost count of how many, advices for like specific projects, assisting some of our clients with things like cleanup notices and show cause letters and investigations with the EPA. And even just legal advice, questions that we have that we, when we're trying to develop new services for clients and that sort of thing, and we're coming across legal questions, we always go to them. So I find them great to work with. But I think you probably met them first on a different project, but in similar circumstances.
Yeah, I clearly remember that. The first time I was involved in a case with Darren was the case against.
Yes.
And then there, of course, was the, you can call it famous, but I've mentioned it on this podcast before, the clown show incident when I called the approval process of one of the biggest councils in Sydney to the face of the Lord Mayor. I called them a clown show. And you can maybe see that as a high or a low point in my career. But that was a compulsory acquisition case. And while that was going on, I was so frustrated, personally frustrated, where I thought, how is this even possible in a mature democracy that a private person can be manhandled like this by a council?
Yeah, that is by a council that is so conflicted, who is being tasked with issuing an approval on land that they're trying to acquire. An approval that would increase the value of that said land that they are trying to acquire. The conflict of interest is just mind-blowing.
There was a different lawyer in different firm involved, and the case was terribly lost, and then Daniel came along.
I don't think this is giving too much away, but I mean, obviously we won't talk about specifics of it, but basically the client had a lawyer involved who was not a specialist in acquisitions, and we were able to introduce them to Daniel, who then got such an unbelievably good outcome for them through the appeal process on the acquisition. Yeah, it got them a very substantial sum of money for their land. And he said it was such a nice experience where it was one of those projects where you get the client calling you afterwards, almost in tears, just thankful for what you did for them. And those sorts of things don't come around every day.
Well, I wasn't crying, but I'll tell you what, when I heard about it, I was definitely fist pumping. Yes, that was such a fantastic victory that he pulled off too, and I did call Daniel up. Anyway, we had a great time talking about something terribly boring, changes to the PoEO Act.
Our boring pods seem to be the ones that get a bit of traction. Gunnar, got a good record.
Yeah, I've noticed. This is highly embarrassing. But never mind. We had a great time talking to Darren and Daniel, about as much fun as you can have when you're in a room with two lawyers, I would say. Oh, and something we need to mention before we dive in is that the audio quality on this recording isn't very good. It has to do with the fact that we actually met with Darren and Daniel in person in their boardroom, and we only had one microphone, and the recording software gets a little bit confused when we talk on top of each other. But never mind, it's all about what they said and not how it sounds, so let's go for it. Okay, what do you want to introduce yourself? Cool.
You can. What would you prefer?
Yeah, I can always cut it out.
I like your intro. You just do the intro and let's just launch into it.
Okay, that's right. I like that. It's like, 5 minutes of how important my guests are. Screw that. We can just jump in. All right, so changes to the PoEO Act. What happened? How fast did that go, by the way? When did that start? Was that triggered by Mulchgate?
To some extent it was. I think it originated when the Labor government made pledges to sort of generally increase the regulation of environmental law. But certainly it was highlighted by the asbestos mulch investigation. There was definitely an incentive to increase regulation.
Yeah, when I heard it, James tells me first, and I said, okay, that's a knee-jerk reaction. It's the first, It's like, oh, we have over the Easter weekend we had X deaths. We need to increase the fines for speeding. That's always the stock standard answer that seems to be coming out, and that you get away with. Oh, I'm doing something.
Yeah. I think that I heard, like, I'm going to stuff up the quote, but it's like, you never want to miss out on a good crisis, whatever that quote is. I saw somebody put something out there, framing it in that way, which is that I think that some of these things have been cooking for a little while, but there was this opportunity that came up where people were, in the right frame of mind, I guess, to accept some pretty major reforms, and I think they took that opportunity.
And that explains the more limited community consultation.
There were very broad changes made, which we'll talk about. But on that point of community consultation, it was sort of unusual in the way, in the limited, well, in the lack of consultation.
Limited was very nice.
Yeah, because I know some of these changes have been proposed in the past. Do you recall any consultation on them previously? Because I don't really.
No, I don't think there was any specific consultation. I think the EPA felt that penalties weren't acting as a deterrent anymore, and that's a little difficult to see when you have penalties of, up to $5 million. But there was some perception that the EPA didn't have sufficient teeth.
Yeah,
I find that difficult to understand when I think they have, the environmental powers are some of the broadest powers available. If you're dealing with a police matter, for example, the only thing they can do is ask for your name and your address, and you've otherwise got the right to silence.
Yeah.
In the environmental space, they've got very, very broad powers to, require information and records to interrogate you. So it's difficult to see how that was seen as a toothless regulator.
Yeah.
But this certainly, apart from increasing penalties, gives them, much, much broader powers now.
Yeah, we were discussing this before, and not only do they now have teeth, but they've got fangs.
Yeah, that's right.
They can really take a good bite.
That's it. So maybe we can start there then. We can start with the penalties. So I think the penalties are something that have been discussed quite a lot in, commentary since the changes have been made. We would like to focus, I guess, on some of the other changes in this discussion, but I think maybe let's start there with just an overview of the penalty changes.
Yeah, so a couple of things. First of all, the tier 1 penalties have doubled, so they're now up to $10 million for a corporation, and that's if it's committed willfully, and $4 million if it's committed negligently. So the doubling of penalties for tier 1 and tier 2.
What's tier 1?
Tier 1 are sort of the most serious offences. So, disposal of waste where there's harm to the environment, leaks and spills and so on. So the most serious, willfully committed offences. Yeah. Those are sort of tier 1. Tier 2 offences are the sort of, the run of the pollution of land, unlawful use of a place as a waste facility, and those sorts of offences. And those penalties, again, have doubled to $4 million for a corporation, and where there's asbestos involved, and $2 million where there isn't just asbestos.
What's the obsession with asbestos with the EPA? I mean, no other contaminant is mentioned that much. It's I think it's just, I don't know. I mean, my personal view, obviously we've spoken previously about how it's quite an emotional, it's quite an emotive thing. And I don't know. I think it's just such a big issue in Australia, and especially I think it's just a legacy. I mean, even to make penalties different, whether you have asbestos involved or not, it's like, oh, there was some PCBs involved in this, particularly bad. So nobody talks like that usually. Yeah. Especially with a contaminant that's not in the most common form, isn't even that bad. Yeah, it's strange for sure.
I suppose the other thing a lot of people don't mention with penalties as well is when there's an offence, the EPA or the prosecutor has an election as to whether they go to the Land and Environment Court for more serious offences, or to the local court if they consider it to be less serious.
Yeah.
And so what they've done now is they've doubled the penalty jurisdiction in the local court as well. So even if they go to the local court, where you would otherwise get a fairly small penalty, the maximum penalty that there is now increased to $220,000. So that is fairly significant.
Yeah, right. And something that I'm really interested in, not understanding how precedent around penalties and that sort of thing works. And I can't remember if under the previous penalty limits whether the court ever applied a maximum penalty or close to a maximum. I actually can't remember if that had ever happened. But what scope do you think the court is going to have now? Or how do you see them going forward in terms of issuing those kinds of penalties? Utilizing those new cases?
It is quite rare for a court to award a maximum penalty, but certainly now that they've increased those penalties to $10 million, the court is required to take into account that, Parliament intended it to be around that level, so they have to take that into account, but it doesn't really stop there. They need to make an assessment of culpability. So how serious was this offence? Was it the low range needing, or higher range? They look at intention. Was it deliberate, negligent, willful, and so on. But also they need to look at parity. So they look at other similar offences and what, just to have some consistency in sentencing. But I think, now that they've increased those penalties, you can absolutely anticipate that there'll be much, much higher penalties awarded in practice.
Yeah, we don't want to get hung up on Moxgate. But obviously, it was a trigger for this. I always speak about that matter. Do they apply retrospectively?
They can. So I think people don't actually understand this legislation, or not all of the parts of it does have retrospective application, and it can relate to incidents or circumstances that existed, before the coming into effect of this legislation. So this act commenced on the 3rd of April, 2024.
Right.
I think one needs to get some advice as to which sections actually have retrospective effect and which, apply prospectively.
Yeah. And that's quite unusual, would we say, to retrospectively apply changes like that?
It's not unconstitutional in Australia to have retrospective legislation, but the legislation needs to be very, very clear that it's intended to have retrospective effect.
Yeah.
And isn't?
This does. So at the back of the Act, there's savings and transitional provisions. And so certain sections, as I say, will have retrospective effect and some won't.
The whole concept of a law being applied retrospectively, to me, is just weird. Like, so you park your car out there and it's perfectly fine. Next week, it's a no standing zone and you get fined. Sorry about that.
Yeah.
Last week, I wasn't breaking the law last week.
It doesn't pass the pub test, is how I would describe it.
Well, it's a basic maxim in criminal law, which is that without a law, there's no crime.
Yeah.
If you want to take an action and there's no law preventing it, it's not a crime. And to say that something may or may not be a crime in the past retrospectively is certainly a deviation. Now, not getting into the specifics of this, but just at a conceptual level, it's something that's developed throughout common law system over time.
But I think the changes here are more around the penalty. So it's not creating new offences with retrospective effect.
Yes.
It's just that the penalties imposed might be higher than they would have been at the time the offence might have been committed. But again, we'd need to take a specific look at the transitional provisions for any specific offence.
Yeah, for sure. That's great. Like we said, I think that the penalty aspect has been spoken about that a bit. And so we're really keen to move on to some of the other changes that haven't been discussed as broadly, I guess. So maybe we can move on first to the preliminary investigation notice. There's quite a lot to get through. So yeah, really keen to have a chat about
They are new, right? Preliminary.
Yeah,
that's a new introduction. What is it?
Well, I think the design intent is it enables the EPA to act more quickly. So previously you'd have a pollution incident and upon the happening of that event, they could issue cleanup notices, prevention notices, or a whole range of statutory notices which they could issue. In the case of a preliminary investigation notice, they could actually act more quickly and potentially prevent the occurrence of a pollution incident or a spill or a contamination event. What they talk about here is something called a relevant circumstance. And if a relevant circumstance exists, they can make an order. So what is a relevant circumstance? It's really a circumstance that poses a risk to human health or the environment from a substance or the deposition of waste, or of course, a pollution incident itself. But so long as they satisfy that a relevant circumstance exists, which is around, potential harm, they can issue one of these notices.
Yeah. They usually, when this happened, didn't they usually issue cleanup notices?
They did traditionally. That, as I say, that were generally tied to a pollution incident or some event that had already occurred.
Yeah.
This allows them to act much more quickly.
Some of the fine print in all of this is an expansion of some of the concepts that we've been dealing with for a long time. One of them is the concept of the pollution incident triggering a cleanup notice. And we have often in the past relied on the question of has a pollution incident occurred, yes or no, as to whether there was relevant grounds, or whether a cleanup notice was valid. This concept of relevant circumstances, which include the deposition of waste, which is, as we know, waste is an incredibly broad concept under the PoEO. These little changes are actually very significantly expanding the powers, I guess.
This absolutely expands their powers. It is new, and it can be issued on the owner of land, the occupier of land, or the person who the EPA believes might have caused or contributed to the relevant circumstances. So it's pretty broad, but it actually goes even further than that. If a notice is issued to somebody and they don't comply with it, the EPA can then issue the same order on a current or former director of the company, or even a related body corporate. So these are very, very broad powers. Yeah, they can require you to do all sorts of things to collect samples for analysis, to report on the testing to the EPA. and also to preserve a site to prevent any disturbance of a substance at a particular location.
Yeah.
So, they are pretty broad. And of course, the work that's done in complying with a preliminary investigation notice can be used against you in a prosecution. So in a sense, you're almost assisting the EPA with its investigation and doing the work for them.
Yeah. Yeah, that's really...
That was the cleanup. That was always in the cleanup notices as well. The first sentence was, "Hey, stop what you're doing," and the second sentence was, "Do a classification of what's going on there."
Yeah. So there's definitely some overlap between a preliminary investigation notice and a cleanup notice, but I think the main difference is that it's preliminary. That the usual trigger for a cleanup notice doesn't need to exist. Here, it's around whether the relevant circumstance exists. So it allows them to get in much earlier on than they otherwise could.
I think in a nutshell, it's moving from cure to prevention.
Yeah.
Yeah, that sounds more like marketing to me. I really in that seminar that I just mentioned before, Jacqueline Moore from the EPA, she said, "Look, we've had some criticism that these notices the surroundings are a bit vague and a bit broad, but trust us, that's always good. We will use them responsibly and sparingly." And I'm sitting there like, yeah, right. Damn, I can't wait for the responsible and sparing.
It's funny you mention that, Gunnar, because there's no merit appeal right. So you have to believe and trust the EPA here, because if you take a different view, there is no ability to actually appeal that on the merits to the Land Environment Court. So you can always bring a judicial review challenge where you say there's been some illegal error made in the decision to issue an order, but there is no right of merit appeal. So it's very, very difficult to challenge these orders in the Land Environment Court.
It's pretty scary. I mean, you don't want to sensationalize these things, but I did see some commentary that talked about, where obviously the consulting space and the thought that, consultants who are somehow involved in a particular matter or a site could be forced via a preliminary investigation notice to, say, collect samples and analyze material and be issued a directive to do so, potentially with no ability to actually get paid for that work or seek any cost of it. And it could actually be very significant.
Well, my raise questions for you in terms of how you frame your retainer.
Retainer, that is such a legal term, you lawyers. Hey, James, I think we should have one of those, though.
or however you call it.
I think the answer is majority of the time we don't really have any provisions or scope for these kind of things when things go wrong. And we often are left holding the bag a little bit when it comes to... We actually recorded a pod just the other week. We haven't released it yet about the Bauer matter. We spoke about some of the things related to that. And what we said, and that was that even complying with existing provisions like Section 191 notices and that sort of thing can be very costly to comply with no ability to get reimbursed for that. So tens of thousands of dollars worth of time often is spent on these things. So
Okay, so that was the preliminary investigation notices that will be used responsibly and sparingly. What are we going to move on to next?
I think maybe the recall notice. That was really interesting, I think.
So I think, it's pretty similar to what's already available, under the fair trading and food safety legislation, where if there's an issue with a food product or there's a safety concern, there was an ability to recall it. That doesn't exist at the moment in the environmental space. So this is a new power. I should say that EPA can't just issue these things unilaterally. They do need ministerial approval before they can issue a recall notice. But with that approval, those notices can actually be issued to any supply chain participant.
Okay, so that would have been a way of dealing with Mulchgate. So you say, hey, you supplied this, take it back.
That's exactly right.
I mean, and we've never seen the fair trade. Is it what ACCC managed, the existing recall scheme?
ACCC is at the Commonwealth level, so fair trading is the equivalent body that deals with New South Wales.
Are you aware of any situations where that's been applied to waste or resource recovery?
I'm not aware of it being applied to waste, or it's regularly applied in the context of unsafe goods or food recalls and so on.
Yeah,
but I'm not aware of it being used in the environmental space.
Yeah, interesting. Yeah, it seems to have kind of been specifically applied in that way. So that's
similar to the preliminary investigation order. These orders could also be made on current and former directors, and also related bodies corporate.
Yeah,
and of course, very high penalty if you don't comply with these new orders.
Things like, on one hand, I get the former director side, but things like that where we say former directors, it goes to that bag of things where you just think it doesn't really pass the pub test. I couldn't say it using that term, but I want to go back to that point we made earlier, which was about how we often hear that people describe the EPA as being toothless, but anyone who's worked in the industry for a while absolutely wouldn't say that. And I'm always shocked when we say things like that, where it applies to, it's that retrospective application and people who are formally involved in things kind of being caught up.
Yeah, I mean, executive liability is probably not a new concept.
Yeah.
There's always the ability where if a company committed a particular offence, they could go beyond the so-called corporate veil and charge, directors and officers and even persons concerned in management as well. But this goes even further. This is, former directors and, related companies.
Yeah. Let's move on to voluntary audits and the change. There was quite a simple change there, wasn't there? What they got removed. So maybe we can go to that point next. I think that's quite significant.
We need some background on that, though.
Yeah, so maybe we can explain what they were and maybe how they were being used and the situation.
Is that you, Dan?
Yeah, sure. So voluntary audits, the former Part 6.3 of the Act, and they provided a mechanism for an entity to undertake an audit and be sure that the contents of that audit could not be uncovered by the EPA. So they could not be uncovered in court proceedings and they could not be uncovered outside of court proceedings. And there was a specific protection for that as protected documents. With a few words in this recent amending act, omit Part 6.3, that's now gone. It's not explained, it's not mentioned in the second reading speeches at all. It's got very little coverage, and the reason for omitting them hasn't been explained either.
Wait, I can explain that. I have 2 words for you. Sydney water.
Timing coincidence, isn't there, with the EPA and Sydney water case? I see.
In court, right?
That's right, and it provided a lot of clarity, and it said, well, this doesn't have to be a formal, structured audit. It can be more along the lines of an investigation. It can consider part, not necessarily all, of an area that they're looking at. And so it was a win, and it provided some clarity.
That's right. Forced them to come up with another topic.
That's right.
And look, I think it was great because we have looked into this in the past. It was actually that case provided some good clarity on some points that hadn't been tested in the past.
Give us the detail of that case. So Sydney Water had had a voluntary audit done on some of their practices, and the EPA did they want to subpoena?
They did.
They did subpoena that. And Sydney Water, which is already kind of weird. So there's the government, one government, telling the other government to F off, right? Isn't there a provision that we don't waste money with our own government fighting each other? Isn't there?
There are provisions for that, but clearly they weren't applicable in these circumstances. I don't know the detail.
Obviously, give me that document. Sydney Water says no.
Yeah,
that's right. And I mean, ultimately, the court said 10 out of the 12 documents that were sought were protected. Really, the key takeaway was that there was uncertainty about whether this had to be a formal audit. I mean, the word audit carries a lot of weight to it, but it did not have to be a formal audit. It could be a much more informal investigation, as long as there was a conclusion in relation to compliance. That was one of the key things that came true.
So that the EPA lost that case?
More or less, yes.
Yes, well, in other 12.
That's right.
That's a loss. And now they go back to mommy and say, they hit me on the nose. And mommy goes back and says, okay, that can't happen again. And take that law out. Or that.
I mean, Part 6.3.
Yeah. I was shocked when I went to go and do some research on my talk and saw the section was completely repealed. And I think it's worth mentioning why voluntary audits are important. The reason that we have such an interest in them in the consulting space is that they allow us to give frank advice to clients and at the same time giving those clients comfort that the advice that we're giving them won't be then used against them. So the intention of them is to have an open discussion about environmental issues so they can then be fixed. When you can't speak openly about things, we know what happens. It gets put underground, and I think that's a bad outcome for everyone. So, voluntary audit, the protections were never about obscuring information from the EPA or hiding or covering up things in any way, although that is how I think that some people from the EPA would view them in that way, especially after this case, right? But in my view, that was never the intention. It was actually a noble outcome that we were trying to get to by doing that. So, I think it is a real shame that it was taken away. We never had those provisions for, the planning legislation or anything. It was just for PoEO. But I think it still served a really important purpose.
It's funny, just the words that you used and the way they framed it. are the exact same justifications for legal professional privilege.
Yeah. And that's really what we're left with now, isn't it?
Really, it is.
Yeah.
So without the voluntary audits, we're moving into the legal professional privilege realm.
Yeah.
We've got some guidance from the Daniels Corporation case that it doesn't just apply when court proceedings are commenced, but you can rely upon legal professional privilege as a way to resist the production of documents, unless there is something that is very clear in the legislation that abrogates that basic right.
So you are a big company and you are engaging a consultant to audit your services or your procedures, and you want this to be between you and your consultant and to remain like that. What's the best way to go about this? How do you get this audit under legal privilege?
Well, you need to bring a third party to the equation, and that third party is a lawyer.
But I think the whole purpose of that needs to be reframed, because I think you need to take a step back and understand what legal professional privilege is. And it's really, as you talked about before, where you want to have frank discourse with your clients and to, understand the true situation. A document is privileged if it's created for the dominant purpose of legal advice. So in the context of an audit, that might be to, assess compliance, to, improve systems and processes. That has to be entirely reframed now, where the person, carrying out the activity would come to a lawyer for legal advice. The lawyer would then engage the consultant under legal professional privilege to carry out that audit for the dominant purpose of the lawyer then, giving legal advice to the client about the outcome and how to improve.
And that advice clearly is going to relate to compliance with laws rather than compliance with best practices. And there's a subtle distinction there.
So that's tough, in other words, to get under that umbrella.
It is. It can be tough, and I suppose there are other issues that arise as well. For example, once you give that document to a third party, that might be received as surrendering the privilege as well. So you have to maintain confidentiality in the document for it to remain privileged.
Yeah, absolutely. So I think it's quite a big deal, and really not something that I think is sunk in, I guess, in industry. Certainly for us, we were using these provisions for clients, and now we're having to kind of look at that again and see what our options are. And I think it's a real shame. I think it will push discussions underground, and it makes it harder for people like us in the consulting sector, where we're trying to give, frank and fearless advice and to give it in writing so that we're protected and everyone is clear on things. It pushes it underground, which makes it very difficult.
Certainly going to increase the nervousness.
Yeah.
And if people go down the path of commissioning audits or anything else under legal professional privilege in order to obtain legal advice, there are going to have to be protocols put in place. There are going to have to be limitations on the flow of information. Things are going to have to be, I think, a lot more thought out and a lot more refined.
Yeah. But, all this will be used sparingly and responsibly. So we're told. You are allowed to laugh, not just swear.
After your previous jokes, I thought I'd just let this one slide.
We can't laugh at every joke. You'll get a big head.
I was afraid you would. I thought you would just don't want to be on the record of laughing.
No. I laughed as well, man.
Absolutely. I think, look, it's just an unknown. It's normal to be nervous about the unknown. And I think that just the extent of changes that are now in front of us, there's just a lot of uncertainty about how it's to be applied. And we'll say this all the time. There are a lot of good people in the EPA. It's just an unknown as to how this is used.
There's so much to be said. Of course, the EPA needs certain powers. Yeah, there's no question about that. I just always I take that back. I often find that those powers are used against the wrong people. They are applied against the very, very low-hanging fruit. Often, that's been our experience.
Yes, in some cases, yeah, for sure. And and that's the thing. And I think it's worth saying, in principle, we support a lot of these things. Darren and Daniel chose to be lawyers in the environmental space for a reason. I expect because you have an interest in it, but potentially because you also have a passion for it. We certainly do. But what I'm getting at is that I think everyone who's involved in the environmental space has, in principle, agrees that we want to get good environmental outcomes. Then the question is really around how do we get there? Yeah. And I absolutely support what the EPA is trying to do. It's just that a lot of these things are quite broad and expansive and, can create a bit of nervousness, I think. So,
fair enough.
yeah, I would listen.
But I mean, there are a couple of positive things that actually we've been talking about, increased penalties and powers. So, I mean, one of the annoying things that James and I think we experienced this before on a matter was when the EPA previously issued a cleanup notice to a client to carry out particular activities. And there was a belief at the time that you couldn't actually carry that out without planning consent. So you were compelled by the EPA to carry out cleanup action, but of course that was subject to getting consent from council. And we worked on a matter together, James, where we then went to the council and sought consent for remediation. And for whatever reason, council refused consent. It was this bizarre situation where EPA is the regulator. They were satisfied that a cleanup action needed to occur, and yet it was refused. So I think one positive clarification in this reform was that it's now clear that if a cleanup notice is issued, and indeed other orders and notices under the Act, you do not need consent under the Planning Act. So that is a positive outcome.
I agree with that. Thanks for mentioning that, because you're right. It's not all bad by any means, and that actually would be incredibly helpful because if we think about the situation, like so the cleanup notice is issued where there's a pollution incident occurring or has occurred. It makes sense to say you want to deal with it as quickly as possible. It's great now that you don't have to then go through a planning process, which can take a long time, as we know. So that's really great. So I'm just looking through some of the other changes that we had here. So another one that's really interesting, I think, is around the fit and proper person test and the ability to prohibit people from holding a license.
Yeah, so they've created a new scheme for prohibition orders, and essentially it's designed for serial or repeat offenders. And what the EPA can do is it could actually commence class 4 proceedings in the Land Environment Court, and it could ask the court to effectively make an order prohibiting a person from applying for or holding an EPL, or it goes even further to potentially ban people involved in scheduled activities from carrying out those activities, either for a specified period or even indefinitely. That is a game changer for anybody who holds EPLs. And this could even arise in the context of an offence where you might be charged with a land pollution offence or some other offence under the Act. And in addition to any penalty, a monetary penalty, which the court could order, it could also potentially issue a prohibition order preventing you from holding an EPL ever again. Yeah. So that is absolutely significant.
Definitely, and it's kind of in line with, I guess, the flavour of some of these changes is that there is a focus on repeat offenders, which again I think in principle is a really good thing. Yeah, I think it will increase people's awareness of their compliance record and the fact that the implications of non-compliance may not just be a penalty at a particular point in time, but it could have long, far-reaching consequences into the future.
It ups the stakes, particularly where you work in that area. Yeah. And if you were to receive an order that prohibits you from being involved in any scheduled activities, it's very broad, and it's going to have a significant impact on what you're able to do with your time and how you're able to earn your income.
Wasn't that the case before? If you were, for example, if you were declared bankrupt, you couldn't run, you couldn't be the director of a company anymore, so you had to get your wife involved. What's the difference here now? Is it just broader and deeper reaching?
Well, it's a specific power. They've actually amended the Land Environment Court Act to allow for the court to make a specific order which specifically prohibits an individual from holding a license or being involved in an activity. So it is a much broader power than what was available before.
So I suppose if you were no longer the licensee, you transferred it to your partner or something like that. I suppose the argument would be made that you still are involved in carrying out of that scheduled activity, and
that's right.
Are these licenses in a personal name or in a company?
Well, it could be either. Development consents issued by councils run with the land. They don't belong to a particular person. They attach to and run with the land. Environmental protection licenses are different. They are personal licenses. And so I think that's the difference. It could prohibit a particular individual or a particular organisation from carrying out an activity.
It will hopefully start to clarify the fit and proper person test. The situations that I've seen in the past where the EPA has determined someone to not be a fit and proper person were slightly limited. And they often seem to be in cases where the licensee was going through, in liquidation or something like that, where it would be black and white, that they were no longer picked up on the license. I think I'm not aware of too many other circumstances where somebody's compliance record, for example, has stopped them from holding a license. I think that this goes a long way to help them do that. Another thing I think we're kind of getting to the end of the list is it just goes to show just how much change came through in this bill. One other thing that I think is really interesting is public warning statements,
otherwise known as the name and shame.
Name and shame.
That's right. So, I mean, what do we think about this? It's quite interesting.
Well, I think what it does is it actually creates a statutory overlay where it has exclusion of liability provisions. So the EPA could go and make fairly broad public statements about a particular organisation. Yeah. You might be thinking, well, that sounds defamatory. You know, you might be able to have some recourse. But in this case, if the statement is made in good faith by the EPA, you know, as a matter of public safety and so on, it actually specifically excludes liability for the person making that statement.
Yeah. I think in terms of outcomes for the EPA, I think that this will be quite effective because in my experience, publication of this kind of information about environmental performance can have a way larger effect on particularly a private sector entity than even a PIN or a prosecution. Mm-hmm. Because what it does is nobody operates a business in isolation, right? You have a supplier network, you have a chain and a web of people around you, right? When this kind of information gets out there publicly, everybody in your supply chain starts to get nervous, may not be the right word, but they become aware of what's going on, and then potentially suppliers stop bringing material to you.
Yeah, no, I mean the public relations risk here is sometimes more critical than a potential penalty. Absolutely,
flow-on effects can be more significant. I don't know if you guys follow the New South Wales Building Commissioner on LinkedIn. I've watched that profile with a lot of interest because he does a lot of this. He jumps on LinkedIn and he puts all these photos up of the building site. Says, "Hey, I've just been at this building site with XYZ builder, and their site's a disgrace, and this is an issue." And I always look at it, and I'm like, "Wow, that's." And I've never really looked into what provisions the Commission has to say those kinds of things, but it must be something similar, right? And that was all part of the building industry shake-up. And that has been very effective in that naming and shaming, I guess, and how I think it's probably hurt a lot of people, but one could argue that maybe they deserved it, but it's not something I've seen before.
Yeah, I mean, it's going to be interesting to see how the EPA uses it in practice, but certainly there's a public interest threshold, so they need to be satisfied that the making of that statement is in the public interest and it has to be made in good faith. If you can't tick those two boxes, there is still a potential liability issue.
Yeah. Look, I don't know if I've missed anything there.
Well, look, it's 80 pages of big legislation, isn't it? Instruments.
One of the things, I mean, if we've just been talking about the PoEO Act, but I mean, people need to appreciate that it amends about 10 other acts as well. Right. It's not just about the PoEO Act. It amends the Contaminated Land Management Act and a number of other environmental statutes.
Yeah.
There's one little thing in there which may or may not be of relevance. I found it pretty interesting, and that's the way that documents can be served. So ordinarily for particular type of documents, you require personal service. But there's a provision in there now that allows documents to be served electronically, so by email, where either explicitly or impliedly email has been used as a form of communication. So if you put an email address in your application, or if you communicate with the EPA by email, that's now an appropriate medium for service of documents that otherwise would be personally served.
Yeah.
I think the other thing that's interesting as well, with preliminary investigation notices, for example, is that those directions can be made orally. So we're quite used to getting, statutory notices in writing. But for these new powers, investigation notices and recall notices, they can actually be done orally and have effect for up to 72 hours before they have to be confirmed in writing.
That's very interesting.
What about material harm thresholds? Have they been increased?
No.
It's about the same. Yeah. Is they the same? Oh, come on. That's not fair.
I think so.
Would have been nice, if the argument comes that, hey, we're only adjusting it to inflation or others. Then the flip side of the coin is when something is considered material harm, you would say that then these thresholds should go up as well.
Yeah, I know what you mean. Yeah, because there's always been
it's that $10,000 and it so that should have been increased at least to 25
index. Yeah, that's it. Well, I think even the concept of material harm has been around for a while. There's a lot of other new terms, I guess, that have been introduced through these changes, which would be interesting to explore. One thing I forgot actually that we spoke about before was the waste certifiers scheme, which I think is very relevant for us. Correct me if I'm wrong. A lot of the detail is yet encompassed in the regs, but at least it establishes the basis for it. Right?
Yeah, that's right. So essentially, creates a regulation-making power for the creation of a waste classifier and accreditation scheme. But as you say, the details to come in a regulation.
Yeah.
Really interesting. It's gonna be interesting. Yeah, I've heard rumors about it for a year now. Yeah, the EPA, I would think, would probably conduct consultation or what the scheme should look like. My personal opinion is I think that doing something similar to what they've done under the CLM Act, basically endorsing third-party schemes. The whole thing around waste is certainly something that should have its own specialized people. I totally agree. At the moment, anybody can classify waste. There's no baseline expertise needed.
I think the other thing that's interesting as well is that in response to the bushfire Survivors for Climate Action case against the EPA in 2021, the EPA's objectives under this act has also been expanded so that they can take specific action in relation to climate change as well.
Yeah, they're going to end up sending at least a preliminary investigation notice or a recall notice to the coal-fired power plants now. This is going to recall this. To recall this. One of the good things that I hope to come out of that is that I would like to see climate change being brought into the EPA's decision-making around licensing, around the sustainability of remediation works, that sort of thing, so that the consideration of the climate impact and the carbon cost of remediation should be brought into decision-making. That's the outcome that I hope that we get from that. Yeah, that would have put Mulchgate into a different light immediately. It puts it in a different perspective. Yeah, it does. Yeah. So thank you, Darren, for raising that, because we forgot that, and it's actually very significant. And you're right in saying that it hasn't really been spoken about much at all. Are there any key performance indicators for the EPA, or is it just one of those things?
No, it's sort of just a loose objective that the EPA should reduce the risk to human health and prevent degradation by taking action in relation to climate change. So it's pretty loose. It's just an objective.
Yeah. All right. Good pickup. I have nothing else. Well, that was awesome, actually, to go through that, because we, like I said, there has not been a lot of commentary on some of those other aspects, and I learned a lot from that, going through it all, and probably not that for many of our listeners. Well, Gunnar gave me a hard time for my policy pod, and it ended up being the one that got some of the most traction, actually. So it also has a fair few of downloads. While some of my favorites, like the highly technical ones, I'm going like, hey, listen to this, ladies and gentlemen. They're a slow burn. I think people will come back to that in time. They're slow. Wow. Thanks for that, guys. Thank you very much. Thank you.